Welcome to News Hour by DLC, your one-stop destination for the latest and most impactful updates from the legal world. From landmark rulings to policy shifts shaping the justice system, DLC brings you in-depth coverage, expert insights, and analysis that matter. Stay informed, stay ahead because in law, every verdict counts. Today is 4th March 2025 and we bring you news that matters. The first news for today is as follows. The Supreme Court of India has raised alarms over the escalating vacancies in the district judiciary, highlighting that the shortage of judges is leading to overburdened courts and delayed trials, particularly in special courts established for offenses under the Protection of Children from Sexual Offences (POCSO) Act. During a suo motu proceeding addressing systemic issues under the PO Act, a bench comprising Justices Bela M. Trivedi and P.B. Varal noted that despite the establishment of special courts, the intended expedited justice is hampered due to the lack of judicial officers. Justice Trivedi remarked, "We don't have judges. Where do we get the judges? All courts are overburdened. We don't get judges. All vacancies are remaining." The bench emphasized that various directives issued by the Supreme Court to expedite trials are not practically feasible without an adequate number of judges. This shortage affects the judiciary's ability to effectively monitor and manage cases, leading to prolonged legal processes. This concern aligns with recent data presented in Parliament by Law Minister Arjun Ram Meghwal, who reported 5,245 vacancies in district and subordinate courts across India. The minister attributed these vacancies to factors such as retirements, resignations, and elevations of judges, underscoring the need for prompt appointments to maintain judicial efficiency. The Supreme Court's observations underscore the urgency of addressing judicial vacancies to ensure timely justice and alleviate the burden on existing judicial infrastructure. Next news. The Bombay High Court has issued a stay on a special court's directive to register a First Information Report (FIR) against former Securities and Exchange Board of India (SEBI) chairperson Madhabi Puri Book and 5 other officials, including top executives from the Bombay Stock Exchange (BSE). The Special Anti-Corruption Court had previously ordered an investigation into allegations of financial fraud and regulatory violations related to a company's 1994 listing on the BSE. This directive was challenged by Book and the other officials, leading to the High Court's intervention. Justice Shivkumar Deej observed that the special court's order appeared to have been issued mechanically without detailed examination, or providing the respondents an opportunity to present their case. Consequently, the High Court has stayed the order until the next hearing, granting the complainant, journalist Sapan Srivastav 4 weeks to respond to the petitions. Solicitor General Tushar Mehta, representing SEBI officials, highlighted that the alleged infractions date back to 1994, predating the tenure of the current officials. He also noted that Srivastav has a history of filing frivolous petitions, with the Bombay High Court previously imposing a 5 rupees lakh fine on him for such actions. The High Court's decision underscores the importance of thorough judicial scrutiny before initiating investigations against regulatory officials, especially concerning historical cases. The matter is scheduled for further hearing in the coming weeks. Next news. The High Court has called for legislative action to relax the stringent twin conditions under Section 45 of the Prevention of Money Laundering Act, PMLA, advocating for a more nuanced, case-by-case approach to bail determinations. Justice Arvind Kumar Verma emphasized that while combating serious offenses like terror financing necessitates stringent measures, applying the same rigid conditions to less severe offenses may infringe upon individuals' fundamental rights. He underscored the need to distinguish between varying levels of offense severity, moving away from a one-size-fits-all approach. Section 45 of the PMLA currently mandates that bail can only be granted if the court is satisfied that the accused is not guilty or the offense and is unlikely to commit any crime while on bail. Justice Verma noted that these inflexible provisions often compel lower courts to defer bail decisions to higher courts, even in minor cases, due to the stringent statutory requirements. The court's observations came while denying bail to Anwar Debar, accused in a corruption and cheating case related to the liquor scam. Justice Verma highlighted that although the legislature's intent to combat money laundering is justified, it's crucial to balance caution with individual liberty. This perspective aligns with recent judicial trends emphasizing the principle that bail is the rule, jail is the exception, even under the PMLA. The Supreme Court has reiterated that while Section 45 imposes additional conditions for granting bail, it does not create an absolute prohibition, and courts must consider the fundamental right to personal liberty enshrined in Article 21 of the Constitution. The High Court's stance underscores the need for legislative reforms to provide courts with greater flexibility in bail decisions, ensuring that the severity of the offense is appropriately weighed against the fundamental rights of the accused. Next news. The Rajasthan High Court's Jodhpur bench recently dismissed a habeas corpus petition filed by a man seeking the release of his alleged live-in partner who is legally married to another man and appears to be his own sister. The court emphasized that there is no fundamental right to engage in a live-in relationship with a married woman, especially when she appears to be the petitioner's sister. The bench, comprising Justices Sri Chandrasekhar and Madan Gopal Vyas, underscored that the Constitution does not endorse immoral acts, and that the court cannot use its discretionary powers to legitimize such relationships. They stated, plainly speaking, there is no fundamental right of a person to have a live-in relationship with a woman legally married to another man, and more particularly when the woman appears to be his own sister. The court further noted that a habeas corpus petition cannot be maintained by someone claiming a live-in relationship under these circumstances, as it lacks legal sanctity. Consequently, the petition was dismissed, and a cost of 10,000 rupees was imposed on the petitioner. This ruling aligns with previous decisions by the Rajasthan High Court. In August 2021, the court declared a live-in relationship between an unmarried man and a married woman as illegitimate, denying their request for police protection. The court reasoned that granting such protection would imply approval of an illegal relationship. However, in September 2021, the court granted protection to a live-in couple involving a married woman, stating that neither state nor society can intrude into the private lives of consenting adults. The court emphasized reliance on constitutional morality over social morality in such matters. These contrasting judgments highlight the judiciary's ongoing efforts to balance individual freedoms with societal norms and legal frameworks. Next news. The Supreme Court of India has halted the recruitment process for the position of Judicial Magistrate of First Class JMFC in Gujarat due to the absence of a mandatory minimum practice period for applicants. The Gujarat Public Service Commission had issued an advertisement that did not specify any required years of legal practice for candidates applying for the JMFC posts. This omission prompted the Supreme Court to intervene, especially since the matter of prescribing a minimum practice period for entry-level judicial positions is currently under deliberation by a three-judge bench of the court. The bench, having heard arguments from various state governments and high courts, has reserved its judgment on the issue. A bench comprising Justice B.R. Gava and Justice Augustine George Massey expressed concern over the Gujarat High Court's decision to proceed with recruitment without awaiting the Supreme Court's impending judgment. The bench stated, "When the court is seized of this issue, we don't appreciate the necessity to rush through the selection process in as much as the outcome of the judgment could have a direct bearing on the qualification to be prescribed for the Judicial Magistrate First Class, Civil Judge, Junior Division." Consequently, the Supreme Court has issued notices to both the Gujarat High Court and the state of Gujarat directing them to pause all ongoing recruitment activities for the JMFC positions until the court delivers its judgment on the matter. The next hearing is scheduled for the 18th of March. This development underscores the significance of establishing uniform eligibility criteria for judicial appointments across India, ensuring that the selection process aligns with the standards set by the Supreme Court. Next news. The Supreme Court of India has ruled that referring to someone as Miantian or Pakistani while in poor taste does not constitute an offence under Section 298 of the Indian Penal Code, IPC, which pertains to deliberately wounding religious sentiments. The case involved an Urdu translator and acting clerk under the Right to Information (RTI) Act, who alleged that during the delivery of certain information the accused, Hari Nandan Singh, used derogatory terms referencing his religion and employed criminal force to deter him from performing his official duties. Initially, charges were framed against Singh under Sections 353, assault, or criminal force to deter a public servant from duty, 298, hurting religious sentiments, and 504, intentional insult to provoke breach of peace, or the IPC. However, upon review, the Supreme Court found no evidence of assault or use of force to sustain the charge under Section 353. Additionally, the court held that Section 504 was inapplicable, as there was no act on Singh's part that could have provoked a breach of peace. Regarding Section 298, the court acknowledged that while Singh's remarks were inappropriate, they did not legally amount to wounding religious feelings under the IPC. Consequently, Singh was discharged of all charges, with court emphasizing that although statements made were in poor taste, they did not amount to hurting the religious sentiments of the informant. Next news. The Na High Court has clarified that under Section 125(3) of the Criminal Procedure Code, CRPC, a husband's imprisonment for failure to pay maintenance arrears cannot exceed 1 month per application irrespective of the total amount due. In a recent case, a husband was initially sentenced to 1 month civil imprisonment for not paying 24 months worth of maintenance arrears. After serving this term, a subsequent application led to an additional 2-month imprisonment order for the same arrears. The High Court quashed the second imprisonment, referencing the precedent set in Sri Kalappa vs. Srimati Yalabai, which established that for a single application covering multiple months' arrears, imprisonment cannot extend beyond 1 month. This ruling underscores the legal limitation on imprisonment duration for maintenance defaulters, ensuring that confinement does not surpass 1 month per application regardless of the arrears extent. Next news. The Calcutta High Court has reaffirmed that an employee's designation, or salary, is not the determining factor in classifying them as a workman, under the Industrial Disputes Act 1947. Rather, it is the nature of their duties that is pivotal. In the case of Swarnakshar Prakasani Private Limited versus the State of West Bengal, and ORS, the court examined the employment status of Mr. Dulal Chatterjee, who served as an accountant at Swarnakshar Prakasani Private Limited since 2002, earning a monthly salary of 18,000 rupees at the time of his termination in July 2013. The company contended that Chatterjee held a supervisory role, thereby excluding him from the workman classification under Section 2(s) of the Industrial Disputes Act. However, upon reviewing the evidence, the Industrial Tribunal found that Chatterjee's responsibilities were primarily clerical, lacking any supervisory or managerial authority. Consequently, the tribunal classified him as a workman and granted him interim relief of 15,000 rupees per month from the date of his termination. The company challenged this decision in the Calcutta High Court. The High Court upheld the tribunal's findings, emphasizing that Chatterjee did not possess the authority to grant leave, initiate disciplinary actions, or supervise other employees. The court stated, "It is the nature of work and not the salary, or the designation which determines who is a worker." This ruling underscores the principle that the actual duties performed by an employee are crucial in determining their status as a workman under the Industrial Disputes Act, irrespective of their job title or remuneration. Next news. The Supreme Court of India has commuted the death sentence of a man convicted of murdering his 2 minor children, sentencing him instead to life imprisonment, without the possibility of remission. The appellant, a bank manager, had been sentenced to death for the murders of his 10-year-old and 3.5-year-old children. The tragic incident occurred after escalating familial disputes, during which the appellant also killed his sister-in-law and mother-in-law. He was tried separately for the murders of his children. In its judgment, the Supreme Court emphasized that the death penalty should be reserved for the rarest of rare cases, requiring a thorough considerations of both mitigating and aggravating circumstances. The court noted that the appellant had no prior criminal record, and had maintained good relations with his family before the incident. These mitigating factors had not been adequately considered by the lower courts. Consequently, the court ruled that the appellant should serve life imprisonment without the possibility of remission, effectively ensuring he remains in prison for the rest of his natural life. The bench, comprising Justices Vikram Nath, Sanjay Karol, and Sandeep Mehta, stated, "We direct that the hangman's noose be taken off the appellant convict's neck." and instead that he remains in prison till the end of his days given by God Almighty. This decision underscores the judiciary's cautious approach in awarding the death penalty, reaffirming that such a sentence should only be imposed after meticulous evaluation of all relevant circumstances. And the final news for today is as follows. The Bar Council or Mahashga BCMG has issued a circular exempting advocates from wearing black coats or jackets from March 1st to the 30th of June each year, extending the previous exemption period which covered only May and June. According to the Advocates Act, 1961, the standard dress code for advocates includes a black buttoned-up coat, chapkan, achkan, black sherwani, or a black open-breasted coat, accompanied by white bands and gowns. However, during summer months, wearing a black coat is not mandatory except in the Supreme Court and High Courts. This adjustment by the BCMG aims to provide relief to advocates during the extended summer period, allowing them to maintain professional attire without discomfort of additional layers in high temperatures. Thanks for listening and consider subscribing to the channel. Well, that's all for today. Keep listening to Legal News by DLC.